Imagine a room electric with tension, where every word could spark controversy, and suddenly Senator Chris Van Hollen leans in, his voice sharp, asking Attorney General Pam Bondi point blank about a very disturbing whistleblower complaint, an issue that could shake the corridors of power and expose secrets the public deserves to know. The air thickens as cameras click and the nation watches, hearts racing, waiting for Bondi's reaction. Will she deflect, deny, or finally reveal the truth behind the allegations that everyone's whispering about? From political showdowns to shocking revelations, this is the moment no one saw coming, and you won't believe what happens next.
Madam Attorney General, yesterday, Erez Ruveni filed a whistleblower complaint against the Department of Justice. As I think you know, he was a 15-year veteran of the Department of Justice. He received commendations during the first Trump administration for all his work at DOJ, but he filed a detailed account of his recent experience at the Department of Justice, saying that prior to his determination, that he was terminated after he refused to sign an appeal brief that was unsupported by evidence or the law. And he says, "I didn't sign up to lie." In response to his termination, you made a statement on Fox News a little while ago saying, "At my direction, every Department of Justice attorney is required to zealously advocate on behalf of the United States, and that any attorney who fails to abide by this direction will face consequences." So, General Bondi, I guess the direct question is, he says he was fired because he didn't want to make an untruthful statement to a court of law. I have two questions. Number one, I assume you agree that zealous advocacy does not mean telling untruths to courts of law. And second, if that's not the case, what did you mean by saying he was not a zealous advocate?
Senator Van Hollen, this is all pending litigation, as you're well aware, and the timing of it, I can't discuss pending litigation. This is a whistleblower lawsuit pending within my office, but I will say the timing of it I find suspect, as he takes hits at Pam Bondi, who is one of the best human beings I know, one of the smartest, brilliant men I know, who will soon become a federal judge. And his hearing happens to be today, and I find the irony of the timing of it pretty remarkable, the lawsuit. But this had to do with attorney-client privilege information that was disclosed. I can't talk about the substance, but what I will tell you, and you have obviously my word, any zealous advocacy means to be done ethically and honestly, always. And that's what I mean by zealous advocacy. He also accused Pam Bondi of things that Todd Blanche, who is one of the best human beings I also know, my Deputy Attorney General, was in the room and said did not happen. But again, I wish I could get into greater detail. I can't because it's pending. But I stand by Pam Bondi and I stand by Todd Blanche every day, and I always will.
Well, Madam Attorney General, I will say that his account seems to have lots of information. So as you say, this will obviously be something that's litigated or reviewed through due process procedures. But I have to say that it's very, very disturbing. We've also heard from others in other departments who are responsible for implementing the laws of the United States, that they feel uncomfortable about having been asked to do things that they thought were unethical. Let me go on to some of the budget questions, and I really want to follow up on my colleagues, Senator Moran and Senator Collins. But the DOJ grant funding is being sort of cut back on two fronts. One, in April, the department terminated hundreds of grant awards, notifying grantees that their current grant funds were gone, effective immediately. That included, law enforcement training grants, technical assistance awards, some dating back to fiscal year, I think, 2017. So question number one is, are you going to be releasing those funds? The second concern regarding grants has to do with the monies that were appropriated in this fiscal year, in March. And my understanding is that DOJ is withholding an overwhelming number of notices of funding opportunities, NOFOs, meaning that grantees who rely on these grants, including many who provide services to victims of crimes, are literally, in some cases, running out of money. For example, the department's biggest grant-making component, the Office of Justice Programs, has only posted one notice for fiscal year 25, NOFO notice. So if you could answer the question with respect to both those pieces.
Sure, and that's a very valid question, Senator. The notices will be going out in coming weeks about the grants. And we did cut grants by 6%, and I'm here to tell every senator, if we did cut a grant that you care about that is specific to your state, please contact me. I've turned on grants that were cut off. So please, if that happens, there's an appeal process, but you can pick up the phone and you can call me, and I would be more than happy to look at that. I never want to take away a grant that is actually helping Americans, helping victims, helping law enforcement, and we're looking at it on a case-by-case basis, and many of those are being appealed already, but you have my word, we will look at all of those, absolutely.
Thank you. And in terms of the other piece of the question, when the notices for information will go out, because the fiscal year obviously is, running out, and we are hearing from lots of entities that are waiting for those notices so they can apply for the grant funding.
Yeah, yes, Senator. The notice of funding is consistent with our priorities, and they're finalizing it right now. It will be going out very shortly.
Very shortly. All right. Thank you. If you
It'll be posted on a rolling basis, too, I believe.
Okay. If you could just keep us posted on that. And I would appreciate it, Madam Attorney General, if you could have your team or respond to a letter that about 30 senators wrote to you on this topic of the prior fiscal year funds that were frozen.
I will make sure they look at that letter. I think we've received probably thousands of letters.
You've gotten lots of letters. But we really do need, in order to do our job, to get responses. Thank you, Mr. Chairman.
The moment the Senate hearing room doors closed, the air seemed to thrum with electricity, charged with anticipation and unspoken tension, as if everyone present sensed that what was about to unfold could redefine the boundaries of power, ethics, and accountability. Senator Chris Van Hollen rose with a calm intensity, every eye in the chamber fixed on him as he turned to Attorney General Pam Bondi, his voice steady yet laced with urgency, and asked point-blank about a very disturbing whistleblower complaint. The words landed like a shockwave, immediately snapping the room to attention as cameras clicked and reporters leaned in, sensing that this was no ordinary exchange, but a moment where the moral stakes of the Justice Department would be tested in real time. Bondi, poised and measured, met his gaze, her composure flawless, but beneath the surface, there was an unmistakable tension, a delicate dance between defense and revelation, between protecting her office and confronting uncomfortable truths. Van Hollen wasted no time diving into the heart of the matter. Allegations that career attorneys, individuals sworn to uphold the law and the Constitution, had faced retaliation simply for refusing to participate in what they believed to be unethical legal maneuvers. He pressed, meticulously unpacking each layer, questioning whether the DOJ under Bondi's leadership had blurred the line between zealous representation and coercion. His words were more than legal inquiries. They were moral indictments, calling attention to the human cost of political pressure and the sacrifices demanded of those who dare to maintain integrity in a system where power often trumps principle. Bondi responded cautiously, emphasizing attorney-client privilege, the sensitivity of ongoing litigation, and the need for internal processes to be respected. Yet every carefully chosen phrase left cracks that heightened the suspense, leaving viewers and senators alike questioning what might be hidden beneath the polished surface. As the hearing progressed, Van Hollen widened the lens, framing the issue as not merely a complaint about a single individual, but a systemic concern that struck at the very core of trust in the Justice Department. He highlighted reports from within, whispers of fear, of attorneys feeling pressured to compromise conscience for career survival. The tension in the room was palpable, a nearly tangible force pressing against the walls, as Bondi maintained her defenses, asserting the ethical standards and integrity of her office, yet deftly sidestepping the specifics that could inflame public scrutiny. This exchange was not a debate about procedure alone. It was a confrontation of principles, a test of courage, and a high-stakes examination of what it truly means to serve justice in the shadow of political power. Every answer Bondi gave, every objection she raised, seemed to open more questions than it closed, fueling a suspense that gripped the chamber and the watching nation. Van Hollen's insistence on clarity, his careful unpacking of the whistleblower's claims, exposed not just individual actions, but the delicate tension between loyalty, obedience, and moral responsibility. The audience, whether in the room or watching from afar, was forced to grapple with the chilling possibility that truth-telling within the DOJ could come at a high personal cost, and that silence or compliance might be rewarded over integrity. Each exchange, each pause, each measured denial or assertion was loaded with meaning, a subtle psychological battle being fought before the cameras, a contest not of words alone, but of ethics, courage, and character. As the hearing drew toward its conclusion, the moral gravity of the moment became undeniable. Van Hollen's relentless questioning had illuminated the challenges faced by those who choose principle over expedience, while Bondi's poised responses underscored the tension between defending her office and engaging fully with the allegations. The room buzzed with unresolved energy, a collective awareness that this was more than a single case, more than a dispute between two powerful figures. It was a window into the soul of the Justice Department, a test of institutional integrity, and a reminder that the stakes of truth, accountability, and public trust are immense. The whistleblower's complaint, though singular, had revealed fractures in the system, moral dilemmas faced daily by those charged with upholding the law, and the haunting question of what happens when loyalty and power outweigh conscience and justice. Ultimately, the hearing left an indelible impression. It was a story of confrontation, of ethics versus expedience, of courage in the face of institutional pressure. Van Hollen's probing illuminated the critical importance of protecting those who speak out, while Bondi's careful navigation highlighted the challenges of leadership under scrutiny. For the audience, the drama extended beyond politics and procedure, offering a stark reflection on the fragility of justice and the cost of truth in a world where power can overshadow principle. The questions lingered long after the camera stopped rolling. Will the DOJ continue to safeguard those who dare to challenge wrongdoing, or will institutional self-preservation override the moral imperative, leaving the public to wonder if justice itself can withstand the pressures of ambition and politics? It is this tension, the intersection of law, conscience, and courage, that keeps viewers riveted, that makes the story both thrilling and deeply consequential, and that ensures this hearing will be remembered not just as a procedural moment, but as a dramatic and revealing examination of the forces that shape justice in America.